ऐसे और वीडियोस के लिए इस चैनल को सब्सक्राइब करें। 3, 2, 1 start. The next set of statutory provisions which would be required to be noticed at this stage are those to be found in the Sports Act 2007. The preamble to the Sports Act 2007 makes it clear that it has been enacted to provide access to the largest number of listeners and viewers on a free-to-air basis of sporting events of national importance through mandatory sharing of sports broadcasting signals with Prasar Bharati and for matters connected therewith or incidental thereto. Section 3 of the Sports Act 2007, on the scope and width of which the court provision the core arguments have been advanced, so as to enable the court to determine the true scope and purport thereof in the light of the provisions of Section 8(1) of the Cable Act 1995. It can be noticed that under Section 3 of the Sports Act 2007, no content rights owner or holder and no television or radio broadcasting service provider can carry a live television broadcast on any cable or DTH network or radio commentary broadcast in India of sporting events of national importance unless it simultaneously shares the live broadcasting signal without its advertisements with the Prasar Bharati to enable them to retransmit the same on its terrestrial networks and direct-to-home networks in such manner and on such terms and conditions as may be specified. On the other hand, Section 8(1) of the Cable Act 1995 carries a legislative mandate that every cable television operator is required to carry on its behalf such Doordarshan channels or channels operated by the network such or on behalf of the Parliament as may be notified by the central government in the official gazette. What is the true legal effect emerging from a joint operation of the two provisions noticed above is the moot question. A narration, though very briefly, of the arguments advanced may now be made, as the High Court in the order under challenge has recorded the submissions advanced on behalf of the rival parties in detail, and as the arguments advanced before us are essentially in reiteration, a brief recapitulation of what was argued before us will suffice. The learned Attorney General, who has argued the case of the appellant, in the main has submitted that the object behind the creation of Prasar Bharati was to enhance leadership. The object of the Prasar Bharati Act 1990, it is argued, is to reach the maximum number of citizens and provide access to news and information to citizens living in the remote villages and hamlets of the country. Similarly, the object behind the enactment of the Sports Act 2007 is to provide access of sporting events of national importance to largest number of listeners and viewers on free-to-air basis. It is in the above light that the provisions of Section 3 of the Sports Act 2007 and Section 8 of the Cable Act 1995 have to be construed. The learned attorney has submitted that the aforesaid provisions should not be read and understood to be confined to retransmission of the live signals compulsorily shared with Prasar Bharati by the content owners only on the terrestrial and DTH networks of Prasar Bharati. Any such view would be counterproductive and go against the mandate of Section 3 of the Sports Act 2007. It is also pointed out the provisions of subsection 2 of Section 3 of the Sports Act 2007 to contend that the possible loss of revenue arising to the content rights holder due to the mandatory requirement of sharing live feeds with the Prasar Bharati has been adequately taken care of by the scheme of arrangement of revenue contained in subsection 2 of section 3 of the Sports Act 2007. It is urged that it is in the light of the above that the provisions of section 8 of the Cable Act 1995 have to be construed. It is further contended that though the Cable Act 1995 is earlier to the enactment of the Sports Act 2007, Section 8 of the Cable Act 1995 should not be understood to have been whittled down by the enactment of Section 3 of the Sports Act 2007 in the absence of any conspicuous indication of such legislative intent. In Section 3 of the Sports Act 2007, in fact, according to Shri Rohatgi, the mandatory duty cast on the cable operators by Section 8 of the Cable Act 1995 is another step in the direction of providing access to the masses, which clearly suggests that the provisions of the two enactments operate harmoniously in their respective fields without impacting each other. On behalf of the respondents, separate arguments have been made by learned senior counsels appearing for the Star India Private Limited and learned senior counsel appearing for the BCCI.